Deirdre Virvo here. Thanks so much for joining me today in Let's Talk Seniors, memory care issues, Alzheimer's, dementia, and Parkinson's. And I had a really fun day today. I just want to share it with you. Today, as a lot of you know, I opened up a senior residential assisted living home in Shelton. It's a very special house. We are having just it's a 6-bedroom, 6-bathroom home. And it's in a regular residence, a 3,200 square foot ranch style house in a beautiful neighborhood in Huntington area of Shelton on an acre property. It's gorgeous, specially made for seniors. So it's beautiful. So I've been giving tours to people like social workers and geriatric care managers and all sorts of different people that work with seniors that could recommend people into the home. So today, and I do them back to back. It's COVID. So to keep COVID free, I have people come every half hour. Today, nobody left. So I had my first tour, second people came, stayed. Third and fourth people came, stayed. So now we had a party. So we had all 6 people all there having a party, but there was so much synergy between everybody because they were in all different aspects. I had a woman that ran she owned all in Fairfield County places, placement agencies, and another geriatric care. Another was an occupational therapist. So they had a lot of synergy and they wanted to meet and greet, and it was great. And I wish I could do more of this. I'm just being very, careful because of COVID and keeping everybody safe, but it was so much fun. To top it off, a neighbor came by to see the house, loved it. She was a senior herself. And then the people that I bought the house from, the lady actually went to a senior center. She went to live in an assisted living in Shelton. Her daughter, who's about 60, came to see the house and she was almost in tears. She loved it. And she's like, can I bring my mom back to see it? I said, of course. I want to invite your mom to come back and live here because wouldn't that just be amazing? Like her mom left because she needed assisted living and memory care. And I'm like, I turned her house into assisted living memory care place. I'm like, I was going to call your mom and tell her to come. So these people kind of just dropped by. So we had like a little party going on today, which I love. So it was really fun. But if any of you want to come and see the house, I'd love to tour it. It's 62 Dogwood Drive in Shelton, but call me first. And we will get you in. And if you have any loved one or senior, it's affordable. We have an amazing ratio of 1 to 3 caregivers. And it's a beautiful home. You're going to want to see it. So I wrote this book. It's called Home to Home, the Step-by-Step Senior Housing Guide. And I wrote this book and also have a workbook that goes with it. My whole plan was to go to senior centers, do these workshops, help seniors know what to do with their homes, know what to do, if they have to move or bring people into their house, if they need a reverse mortgage. And then boom, went to my first senior center and COVID hit. So if you want a book, call me. I am happy to mail them out. I've been mailing them out right and left to people. Just call me or send me an email or write to me here, and I will happily mail you a book. Today we have a fabulous special guest on, Edward Kelleher. He is an attorney residing he actually resides in Sandy Hook, but he works out of Danbury and does the entire Fairfield, New Haven area. He specializes in everything to do with, he does real estate. He's done a lot of closings for me, but he does real estate, probate, wills, senior planning, estate planning, probate, and anything to do with your trusts. So right now he's in the middle of doing mine, and they could be quite complicated, but he knows his stuff. So without further ado, we're going to introduce Mr. Edward Kelleher to the screen. Hi,
Deirdre.
How are you?
Great. How are you today?
Thanks
for having me on.
I'm fabulous as always. But we're happy to have you on. And first, tell us a little bit about yourself personally and how you got to be a lawyer. How about a little background?
Okay. I've been a lawyer since 1986. I grew up in Washington, D.C. and moved up here with my wife, who's from Westchester County, and started work with a firm in Bridgeport and another firm in Waterbury. And I got my own shingle to do my own thing. And I've been focusing and concentrating my practice on residential real estate primarily and estate planning, probate, for about 15, 20 years now. I love it. As and I were talking before the show, what do I like about it? And honestly, it really is sitting down with people and figuring out what they need in terms of planning, and setting it up for them. And so many people have said to me after the fact, said, "Oh my gosh, this is such a huge relief. That's been on my mind for a long time, and I just never did it." And so I'm so glad that we've done this, because it's just check the boxes.
And I think right now during COVID, I mean, we could be killed in a car accident at any given moment, right? But I think so many people are really, I know I am, thinking about our mortality. And I know you're super busy right now with all the real estate closings and all the, New York relocations and everybody coming in and everybody doing their will. So thank you so much for coming on and giving us your time. I really appreciate it, because there's still people that are a little in the dark and not sure where to start. But I know a few more things personally about you too. I know that not only do you have a fabulous wife, but you have brilliant kids, one with an MBA and one that just became a doctor. Yep. Amazing. Yep.
Very proud, yes.
Smart kids, smart parents. That's always helpful. And I know you're a Yankee fan.
Yes. Yep. Love the Yankees.
They're playing now, right?
Yeah, it's a crazy shortened season, but they're playing.
Okay, but nobody's in the audience.
People are still enjoying it. I get a kick out of the watching to see the placards that they put in the seats behind home plate. See where's Waldo back there, or Bernie from Weekend at Bernie's. Yeah. They put
That's great. They could put in a whole bunch of celebrities, like they're all watching.
Right.
Yeah,
right.
That's so funny. So there's no roar of the crowds, or are they making that noise?
It's all artificial. It sounds an awful lot like a regular game, though. Yeah.
That is so funny. Okay, that's great. Well, I know that you really care about your clients and what you do, and you spend a lot of time with them. And you even did my daughter's, condo recently, and spent a lot of time explaining that to her, which I thank you. So why don't you tell us, just start with the basics. If you're young and you don't have, you're not married, you're 25, 35 years old, and what do you need? Do you need a will?
Well, if you're young and you really don't have much in the way of assets, the state has a plan for who gets what in the event of your death. And if you're not married, you don't have any children, then the state basically takes care of it. But if you don't have that much in the way of assets, your will is not your biggest concern. What you should really strongly consider, though, is having a power of attorney, signing a power of attorney so that someone can deal with your property in the event that you can. I always tell my clients that when sitting down with them to do planning, we're planning for a couple of things. We're planning for incapacity. You have a stroke or a car accident, whatever reason, you either lack the cognitive ability or the physical ability to act on your own behalf. And we're also planning for what happens in the event you die. A lot of people just really don't pay enough attention to the possibility that they won't be able to take care of their own business. So that's where the power of attorney document comes in. And you really, anyone who has a bank account or any kind of accounts needs to have something like that, so that somebody can do their banking, help them with their banking, or just to deal with things if they can.
So you're saying if you're incapacitated, somebody needs to have your power of attorney, and is it like a limited power of attorney that's only if you're incapacitated, like they can't take advantage and have your power of attorney and go into your bank account, if you're fine?
Well, that's always a risk that you run. There is available we can have what's called a springing power of attorney, which only comes into effect if you become incapacitated, and that's really a springing power of attorney. So it says right in the power of attorney, this will only become effective if two doctors have certified that I am incapable of managing, taking care of business, for lack of a better word. The problem with that is that physicians are extremely cautious about signing that kind of thing, because they know that, well, this means that the person who's named in the power of attorney all of a sudden can start dealing in your property, and they don't want to sign something that might come back to them. So I know I have had clients. We haven't really done springing powers of attorney as a general practice for many years now, because that's such a big issue. So, I mean, you do have to have someone that you trust implicitly, whether it's a parent or a brother or a sister, to have this authority. You can also put limitations in the power of attorney as to how broad their authority is. So we try to tailor the power of attorney to the needs of the client. In a husband-wife situation, especially if they're, it's a solid marriage, they've been married for a long time, you've got pretty broad powers in the power of attorney, you said.
But I hate to go into the hospital with my tonsils out and give my brother a power of attorney and have him clean out my bank account.
Well, then don't.
No, but
I mean,
whoever is here. The power of attorney, Ed, does the attorney hold the power of attorney, or does the person that has it hold the power of attorney physically?
No, I tell my clients, look, keep the power of attorney available, so that if this person needs it, you can have it. You just keep it in a safe place, and so that if your agent needs it in order to act on your behalf, then it will be there for them to use. The alternative is a very costly and time-consuming procedure of having a conservator appointed through a court process, and that's expensive. It takes time, but it does have the advantage of actual continuing oversight by by the court, by the probate court. And frequently you'll have, professional conservator, people who do that kind of thing for a living, and are very good at it, appointed as your conservator.
So let's say you have this power of attorney, and just to figure out exactly how it works. So I have a power of attorney in my hand for a friend, and now they're in a car accident. I can go into their bank account and pay their mortgage and pay their light bills. Is that what I could do? Well,
yeah, first you need to, let's just say a bank, for instance. That's really most typically where it's needed, is basically you would have to go to the bank and present the power of attorney and explain to them the circumstances. They'd want to know, because they're very leery of powers of attorney. But the law changed in 2015 to address the fact that banks were reluctant to take powers of attorney. But by the same token, people need them. I mean, you can't have the person who's disabled come and say, yeah, this is my power of attorney, obviously. So you present the power of attorney, and the bank, or whoever you've given it to, has a limited amount of time to evaluate it and determine whether or not they are willing to, whether or not they want additional proof from you as to its validity. So there are ways where they can challenge it, but it's much more limited than it used to be. They can't just say, no, we don't take powers of attorney that are more than 6 months old, which was practice.
So if you're older, is it good to assign, let's say, one of your kids as your power of attorney, or is it a better practice to put them, like, let's say, on your bank accounts, that they can't be a signer, but they could? I don't know how that works.
Well, I mean, if someone is a signer on a power of attorney on a bank account, honestly, I think that you're better off with them having your power of attorney. They've got fiduciary duties. There are procedures for the probate court to view the actions of an agent operating a power of attorney. You can make them a signer on the account, but really, at the end of the day, you're really putting your trust in them.
Okay. So you need a power of attorney, and then, but that's not good for your health care, is it?
Now, healthcare is a different document. It used to be that you could kind of use the power of attorney had some healthcare provisions, but that hasn't been the case for many years. So instead, what you have is a document designating a healthcare representative. And the healthcare representative document says that if you're incapable of communicating with your doctor, then because you are the first person that the doctor communicates with. What the representative document does is, look, doctor, if I can't communicate with you and understand what you're telling me or instruct you about my care, then I authorize this person to decisions have. And that's also a powerful document. A lot of times you want a different person to have that kind of the power of attorney might go to someone who's good with finances, and the healthcare representative might go to someone who's better off at managing your medical situation.
Now, is this also like the pull the plug document, or is that a different thing?
They would be, if you can't, I mean, the doctor's always going to take the direction from you, the patient. But if you're not capable of making that decision, then they'll turn to the representative to make the decision.
So you should have at least these two documents, no matter what age you are. Do you need others? Do you need a will?
I'm sorry?
Do you need others?
You need, well, those are the two critical things. I recommend that people have a living will, which is the document which says what type of so-called heroic measures you want taken to keep you alive if you really typically at the end of long terminal disease, or if you are in a permanent coma that you really doctors don't think you have any chance of recovering from. My clients will typically sign this living will saying, look, if that's the case, then don't keep me alive with breathing respirator or a feeding tube. Don't do CPR on me to revive me if my heart stops. Those are kind of the typical provisions in a living will. What it really is kind of it's a direction to your healthcare representative and also to the doctors that really kind of don't keep me alive if I'm really for no purpose.
Can you do the Walt Disney checkoff thing where they freeze you forever and then you could come back like 100 years later?
Yeah, you can do
that. Provision? No,
that's not part of the usual thing.
Should be. What? Yeah. Doesn't everybody want that? No. Okay. So at least these three.
Yeah. And I think really everyone. Really, what I typically do is if you're going to do those things, then you might as well have a will done. Because what's in a will, the will I like to, and this really applies to people of all ages. It puts you in control of what happens with your property. It's your opportunity to say who you want to be managing your estate. It avoids disputes among children. Basically, it's one way to make sure that the wrong person doesn't get your estate. As I said before, the state has a list of who gets what in the event that you die without a will.
So
that's called an intestate estate. And people are surprised to find that their spouse might not get their entire estate. If they have children from a prior marriage, there are different rules. So the will is really, it trumps all of that. It says who gets what, and it also says who you want to be your executor. When you do when you do a will, I also have a conversation. Look, do we have any children that are disabled that you need to provide for? Do you have any children who are even in a rocky marriage that you don't want to leave them an inheritance that then can be part of a property division in a divorce. If you have a child who is a spendthrift or has a gambling problem or something like that, their inheritance can be put into a trust, essentially to protect them from their own bad judgment and or from their own creditors, so that your inheritance, what you're leaving to your loved ones, doesn't it goes where you want for the things that you want it to be used for.
So who holds on to that? So I know people that put it in, and let's say their life insurance, and their kids aren't allowed to have it until they're 25. Who holds on to that money?
Well, a trustee. In a trust can be either set up in the will or by a separate document, revocable trust, for instance, living trust. And the trustee is a person that a lot of times might be the same person who would have your power of attorney. Someone you trust, who ideally is good with finances. Frequently, they'll hire an investment advisor. Most often, they'll hire an investment advisor to help with the investments and decide what to invest in. They also need to be someone who typically, especially if there are younger children involved, or children in their 20s, the trust might have provisions in it so that the trustee has some discretion. Maybe if the child needs a car or needs education, the trustee can exercise some discretion in that regard. So they really kind of have they're standing in your shoes as a parent in some ways, in terms of. But it's an important job.
What if you have a business? Do you need a different kind of will for your business to, like, let's say you pass away when you're in the middle, you have a business. What happens?
Well, hopefully you've done succession planning with your business. You've got someone who can step in, or a vice president, or assuming we're talking about a small business, who knows the business and who kind of can take over where you left off. This might even happen if you become ill. You need someone to do it. For a lot of people so that's really kind of a business succession planning. There's a whole, if you want to leave the business to your family, that's a whole process to go through, in terms of getting shares in the business over to the children, and typically that involves some tax planning. But generally, there would be a special trust, probably deal with the business in the context of business organization itself, and so with the will and the trust.
So Ed, let's say you don't have any of this in place, and you're 35 and you're in an accident and you die, and you have a bank account. Who can go in and get your money? Like, who can go in and get your money to give you a burial? Who could, how's that?
Well, if you don't have a will, then someone needs to apply to the court to administer your estate.
So is that a parent or a sibling?
A parent or a sibling, yes, would step in. They'd step up, and because obviously you can't. They'd apply to the court, and the court would say, "All right, you look like you're a suitable person to do this," and then the court would give you the legal papers that you need to show to the bank, saying, "All right, I'm administering this estate." It's kind of similar if you died with a will and you have an executor named. Either way, that person has to have legal authority to act on behalf.
So are wills filed with the court?
Only after you die, and
so how do
only if you have sorry.
But how do you prove that there isn't a will?
How do you prove that there isn't a will? Well, if the administrator the person who comes into court basically says, we look for this will, look high and low for the will, and we can't find one. if there's a will, it typically, if you get I get all the time on a listserv emails from other attorneys around the state saying we're looking for a will for Deirdre Virvo, and other lawyers who may have drafted that will and have a copy of it. At least we know a will exists, and that way it avoids.
You keep a copy of all the wills for your clients?
I do keep a copy of all the wills. Yes. Yeah.
So oftentimes attorneys are looking for the will.
Yeah. They might. Children, for instance, their parent has died, and they don't know who might have prepared their parent's will. They go to their own lawyer, who doesn't know which of the lawyers, the thousands of lawyers in the state might have prepared the will, so they kind of reach out to everybody, and sometimes you find it.
That is why it is so important to do this estate planning now. Like this is why I'm doing it with you, right? Because I feel like if something happened to me, my poor kids, they wouldn't have any time to grieve. They would be having to figure out what to do with all my stuff. Like they wouldn't have time to figure anything out because there'd be, to grieve for me because there'd be too much to figure out.
Right. And that is one of the best reasons is to get this done now is so that it doesn't interfere with that whole process. This is taken care of. It's done.
And for probate, so it passes through with less tax ramifications and all that. So now let's go a little further. When you're a little older and you have stuff, assets, what do people need then besides all these things?
Well, they need to review the will and the planning that they've done. 15. A lot of times people will do a will when they've had children, and they feel it's really incumbent on them to find and name a guardian, someone to raise their children that they can. A lot of times that's when people will have a will prepared. And sometimes they won't look at their will again until the children are grown. They're 25. Well, it's time to update my will. So at that point, they've got their finances are more or less in order. They are retiring. They know what's what. They have a pretty good sense of the capability of the children. And they also, the people who were their parents, they might have named in their original will as guardians or executors, now too old for that job. Children or a brother or sister might be of their choice. So it's time to update. You really should review your will at least every 5 years. And whenever there's any kind of a significant change in your finances, if you've got an inheritance.
Or if you buy more property, if you get divorced, if you get remarried, if something happens, if you come into inheritance, right? So my dad used to do a thing, and I'm wondering if this is a thing. So every time they went on a cruise, for instance, or somewhere they felt they could perish, my dad would update his will, put it in a sealed envelope, sign his name to the back of it and leave it on his dining room table. Now, of course, they never perished in a travel accident. So then, I guess he just threw them away. But I think that was his idea of updating your will. Is that something that would uphold?
Well, you can't make there are very strict rules for making a will. You need to signed, and it obviously needs to be in writing, signed and witnessed by two people. Not the kind of thing you can do.
It has to be notarized and witnessed.
It doesn't need to be notarized. There are provisions so that you don't need to call the witnesses into court. So we do that. But it needs to be witnessed in Connecticut by two people. It needs to be in writing and signed by you. So as far as I know, your father lived in New York. I'm not sure. I don't know that would even. I'm not sure about what he had in mind. It may be that he wasn't necessarily updating. He was just putting it out there for people to find in case they needed to. Instead of saying, "This is my."
I never opened it because it was like case of death kind of thing.
Right. Yeah.
Well, it was. So, and what if you're living in Connecticut, for instance, and you have a will, and then you move to Florida, or you move to Arizona? Do you have to redo your will for that state? Is it state by state, or is it federal, or?
No, it's your will, unless there's your will be recognized in another state. There may be some reason you may want to take a look at the will when you get to the other state, especially if that's going to be your new domicile, permanent residence, um, to make sure that you're not missing out on different opportunities. Uh, Occasionally, there might be some restrictions in it that may be a little inconsistent with what we do here in Connecticut. Your will drafted in Connecticut anywhere. It doesn't typically control properties in other countries. It'll control the properties of the United States.
So Erica, my daughter Erica, when she was young, maybe 23, had an incident that had her make her own will, her own power of a POA, and her own healthcare rep, because she was teaching in Korea, and another kid that she was teaching with, right out of college, died while she was there.
Uh-huh.
Did not know him well, but they were paid quite well in Korea, so they had bank accounts there, pretty big bank accounts, because it didn't cost them anything to live there. So they had, significant money for a 23-year-old in a bank account there. When he died, she had to find his parents on Facebook because she didn't know him. And then she was concerned, how are they going to get his stuff, his body, and his money out of Korea to Indiana, wherever they lived. And I just think it made her really think, oh my God, what about my money? What about my stuff? What? So she did all this when she was young,
right.
And she's forward thinking. But there was an incident, so I think this is when people think, oh my God, I should do this. But
that's usually what it takes. Yeah.
It takes an incident or seeing something else or seeing a parent. I buy a lot of houses to flip, and I bought a house in Darien recently, and it was in probate 4 years. 2 brothers were fighting over it because the father did not have a will. And he had 2 houses of equal value next to each other, and the brothers spent 4 years fighting over them.
Right. Must have cost a fortune.
It cost a fortune, and they each just got 1 house each. They were worth the same amount of money, but they fought for 4 years over it. Yeah. So, and it was quite traumatic to their relationship, obviously, and to their finances, and so it was terrible. But if the parent just thought ahead, they could have been like, you get 1 house, you get 1 house, let's be done.
Right. Right.
And we're good to go. But so we need a will. Now, what about trust?
Well, a trust is we hear a lot about revocable living trusts that you can set up. A lot of times people want to set up trust so that they can avoid probate. That's typically what people are thinking of when they're setting up a trust. The trust is, in a lot of ways, a substitute for a power of attorney and a will, because it has what you do is you create the trust, and then you put your assets into it. You can make yourself the trustee, so you still have control over it. But the language of the trust says, if I become incapacitated or if I resign as trustee, typically if you suffer from dementia or you just, whatever reason, you've named in the trust a successor, somebody to take over for you, typically a spouse or a child. And they step in. It's a fairly seamless process. You don't need court approval. You don't need basically the succession of trustees is provided right for in the trust instrument itself. And it's, as I said, it's a pretty seamless way to transfer control over your assets. And they also have, as I said, it's a will substitute, because trust will say in it, in the event of my death, this is what happened. So it'll say, perhaps if my spouse survives me, then my spouse gets everything. You can incorporate into the trust a tax thing, becoming less and less of a problem as exemptions go up. But say if my spouse survives me, then if everything goes to my spouse, it would be for my life. Typically, the spouse will have a trust that is the mirror image or reciprocal trust. It's the same thing. And if spouse doesn't survive you, then you've left your estate to your children. And this is what I said before about the provisions you can put in a trust, so that, for instance, if you've got minor children, you put their money into their inheritance into a trust, and you may have your trustee dole this money out in, at least in principle, the 25, 30, 35, depending on how much money you're talking about.
So you could have a revocable trust, and within that trust, if you pass away, it could make other trusts if you have underage children?
Yes, and that's one of the best uses for it is
Okay.
because then your trustee, you've identified a person, your trustee, to manage that money. Otherwise, a child would get their inheritance when they turn 18, which could be disastrous. Just, it could be great for the child.
I know a family that happened to.
Yeah.
Kids, they were living in New York, and they bought like one bought a Mercedes with all the money she got. I don't know, it was like $25,000 at the time. This is years ago. And the other did something equally as unnecessary. And then they had no money to go to college.
Right.
And they couldn't afford the insurance for the Mercedes. Like, it's like, you don't need a Mercedes at 18 years old because, all of a sudden it was like nouveau riche, we have this money. So, yeah, giving it to an 18-year-old might not be the most prudent idea. So,
yeah,
what about the look back to go to nursing homes?
Well, look back is 5 years, and you have to, basically, it's part of the spend down process. In order to qualify, you can obviously go to a nursing home and spend your own money. What you're talking about is qualifying for Medicaid, Title 19. And in order to qualify for Title 19, you can't have any assets. It's a program that's designed for people to take care. And that requires careful planning and spending down assets in a good way, and still making provision if the spouse who will not be going into a nursing home. That needs to be the right way.
So so my mother-in-law just passed away a few months ago, and we sold our house about 15 years ago, put it into a trust, and she was, late 70s at the time, and then she lived fine for about 8 years on her own, and she used her money that the trust offset, and then she went to a nursing home for the past, 7 years, and we didn't use her money, just a little bit a month. So she actually had six figures when she passed away because Medicaid kicked in like 7 years ago. So that's been paying for her. So there was money, surprisingly, left over, and that was nice. And that was just because if she didn't put in a trust, she would have used up all that money.
Right. Yeah. Yeah. So it's a special trust that are. They're deemed not to be your property. If anything is deemed to be your property, you are supposed to be using it before Medicaid kicks in. So that was a trust that was set up. I haven't seen it, but that was a trust that was set up for that precise purpose.
So I can imagine everybody comes to with a million different things. They have assets, divorces, stepkids, second marriages, different parents, different needs, So how long does this take to figure out what to do with their money? Like, do you sit down for hours and figure it out and put together a unique plan for them?
It depends. My process typically is, most people don't have that complicated situation, or, I typically will send out to clients a questionnaire in advance to kind of have them go through to get the basics, where their assets are, because that's kind of the first thing that I need to know is what the assets are, how are they titled, are they what we call a probate asset, which means it's your property alone and it will be controlled by your will. Or is it a non-probate asset like life insurance or a retirement plan or a jointly owned property? those are not controlled by a will. People frequently don't understand that the will, you can have a will and think you're making all kinds of great plans, but if your 401k says everything goes to your first wife, you know,
So your 401k and your life insurance don't go through you don't get to determine who gets those?
you do, but you don't do it in your will. You do that by way of your beneficiary designation.
Oh, so yeah. So when you make the life insurance, it says, who are your beneficiaries?
Yes, exactly.
3 kids, I want to give 33.3% to each one, like that, right?
Right.
So that's outside the will. You don't have to rename that.
That's right. Yeah, that's what's called a non-probate asset, because it's not the ownership of that property doesn't pass by virtue of an order of the probate court. It passes by virtue of an agreement that you have with the insurance company or with the IRA administrator. That's how that works.
There's a
So
lot to
yeah, it can. So that's why it's very important to kind of, when I sit down with people, we have the questionnaire, we fill it out, and as we're talking, I'm getting to know them a little bit, getting a sense of what we want to know, what they want, their objectives are, what issues might exist, and as I said before, children who might be irresponsible, or children who might be like the most responsible children you ever saw, and in an hour and a half, sometimes longer, we'll might have meetings for 2 hours the other day with clients. We talked about a lot and sorted through a bunch of issues, and had ended up with the outlines of a plan. And then I may send them away to get a little more information for me. Sometimes they don't know who the beneficiary is of a life insurance policy, and then but in the meantime, I've then figure out exactly what the plan should look like. Do they need a trust? Do they have to have a special needs trust or a supplemental needs trust for a child? Do they have minor children? Are they going to have a guardian for these child? Is the guardian going to be different from the trustee who's running the money? These are a lot of the considerations that's my job.
That is a pretty big job.
Yeah, it's fun.
You have to know a lot of laws. I guess that's why you're a lawyer. You have to know a lot of rules and laws.
Well, it's a lot of it's common sense, but yes, yeah.
So you also deal with a lot of people who, when a spouse dies, and they come to you because they want to know what to do. Like, do they have to do? Because you have to do what, a final tax return. There are things you have to do when somebody dies. A lot of people don't even realize that.
Right. Well, the person who died had income, presumably, or maybe they didn't. But if they did, then they had to file a final tax return. If they had an estate that had any assets, then the estate then will need to file tax returns if it had income. The estate files a tax return for the estate tax, Connecticut estate tax and federal estate tax. Most people really just need one for Connecticut. And really, the vast majority of people don't have to pay any Connecticut estate tax. The exemption is going up every year for the next year or so, and then it will be up over 7 million. So
you don't pay anything if you have a value worth of 7 million or more.
I'm sorry.
You don't have to pay anything until you have a net worth of 7 million or more.
As I say, it's going up, but I think it's next year it goes up to 7 million.
I'm like this close from that.
Good. I'm happy.
Yeah, that'd be nice.
Yeah. But the thing is, you have to prepare an estate tax return, and that gets filed with the state, and presumably if you don't have any estate tax to pay, then, and it's based on the property you've given away during your life or by your virtue of your death.
But when you have a spouse that dies, they really should come revisit you again.
Oh yeah, they have to. Yeah.
Now what to do with my will, with my estate, to file a final tax return. What do I have to do with my accountant, right? I can't tell you how many houses I buy in probate from somebody whose spouse died a dozen years ago, and they never thought they had to do anything. They're like, the house was owned, and we both own the house. And I'm like, well,
Right.
You have the right to sell it. Do you have the right? And they have no. They just assume they do. And then we're getting to the closing, and because I know the questions to ask, they
Well,
can't. But we do
yeah,
have
you have.
a question here. We do have a question for you.
Yeah.
So we have somebody who wants to know if you can serve clients that do not live in Connecticut. We have Suzanne Murphy Holmes asking this question. Are you just locally in Connecticut, Ed, or can you help with people outside the state?
Really limited to. I generally limit my practice to advising people inside in the state of Connecticut, because so much of what I do is really based on Connecticut law. I can't really know the law of every jurisdiction, so
So every state is different. Like I know Florida has like a Homestead Act, and you avoid probate for a lot of things. And so every state is different.
every state is different. Yeah, I mean a lot of the rules are the same from state to state, but every state probably has its own quirks, and I don't. There are rules against practicing law outside the state where you're admitted to practice law. So I'm not admitted to practice law, say, in North Carolina. So I can't advise anyone on what the law of North Carolina is.
So Ed, do you know which state is the cheapest to die in or the best to live in as a senior? Because there are like 13 states, I believe, that are way better than. Well, there are a lot of states way better than Connecticut, tax-wise, but is that something that you would know as an attorney? Like, what are the good states for? I know, like Florida and Delaware, don't tax certain things. I don't know whether it's Social Security or your pension. And
But I think Connecticut is terrific, frankly. Now that they've raised, especially for people with money, now that they've used the state tax exemption, that drove a lot of people out of the state. When if you had more than $2 million, you were paying state tax. By raising that, they really recognized that was a big problem. I think the social safety net here in Connecticut is terrific. But as a senior, you're worried about income tax. You live in a state. You might want to live in a state where you've got protections for assets. Some of the states out west are better for that. Some of the older assets. But for most people, honestly, I think maybe not this week when it's hot, 90 degrees, but for the most part.
I love the heat. What do you mean? I love the heat. This is great.
Yeah.
So you think Connecticut's a pretty good state? Well, ever since they raised it to $7 million, because it isn't too hard to have $2 million if you have life insurance and a house. Is life insurance part of it?
Exactly.
Not
So a lot of people
were $2 million worth of assets when you die, but $7 million takes a little effort.
Right. Yeah.
So that's good. So in closing, because lawyers like to do closings, why don't you tell us in closing what? So you were telling me before that your best prospect is really, or people that should come to you anyway, early on, are people in the 25 to 35 year range that are about to buy a house, because you could be their lawyer. You could do their will planning, their healthcare proxy. You could do their home closings, their real estate purchases. You could be their go-to lawyer. And then when things change, when they have kids and they want to do something else with their will, with everything, you could update it and upgrade it. When they get older, they have parents that need help, they could bring their parents to you for estate planning. So your best prospect, the best clientele, is somebody a little younger that can, stay with you you could be their lawyer for quite a while, which is an asset, or people that are older that really need help, knowing what to do with their estate. And when I say older these days, even though people are not retiring at 60, 65 anymore, people are living to be in their 90s, 100. So they're not thinking like at 60, I better plan for retirement at 65 and death at 70, right? So, but people should be thinking younger.
Right, absolutely. I want to be the family attorney. I think that everybody should have somebody, an attorney who knows your family. They know you, and they can be there to answer questions. I don't do criminal work, but I can refer you to someone who does.
We have another question. Sorry. If somebody wanted to leave a lion's share of their estate to their church or nonprofit, does that take special planning?
You can really optimize. You can optimize your situation with some special. You can leave a lot of your. You can obviously leave your estate to a church or to a charity, and without doing any special planning, you can just say, "In my will, I leave this to this charity." But there are ways to optimize your own tax. Little planning.
Is that a way to avoid taxes? So let's say your estate is worth more than $7 million in this state. And could you leave your kids less than $7 million and then leave the rest to charity and not be taxed on it then?
Yeah, there are techniques that you can use to yes, yeah. Basically, it's complicated, but yes, yeah. If at the end of the day a charity is going to get the money, then you can set up various trusts in order to avoid paying the estate tax.
Well, my mom used to threaten and say she was going to leave all her money to her cat. I'm just happy the cat died. So anyway, thank you so much, Ed, for coming on. We've really enjoyed the conversation. You are a wealth of knowledge, and I know how much you care for every one of your clients, and you really take the time, and you're so patient with everybody. And I know you've done 2 of my kids' closings, and they really felt like they were in safe hands with you. And you really explain things to them, maybe more than they need to know. But no, you really did a good job. And so they were happy. And I can't wait to have my own trust done, which I know you're in the middle of. And I'm excited to see it because it gives peace of mind. And I feel sometimes I'm up nights like thinking, I just want everything settled, so if anything happened to me, it would be settled. Like it's one thing you don't have to worry about, so it's just peace of mind is what we're all looking for. But thank you so much. Will you come on again?
Thanks for having me.
Yeah.
It was really a lot of fun.
Really appreciate it, Ed. So Ed Kelleher, attorney, 203-518-5602, specializing in real estate, probate, estate planning, practicing. Those are your areas of expertise, right? So we really appreciate it, and we will be talking to you real soon. Say hi to the family.
Okay, thank you.
Bye, Ed.
Bye.
Thank you so much. I really appreciate it. And thank you. He's just so sweet. So he is not, the attorney that's a shark. He's not out to eat other attorneys. He's out to really look out for your best interest, and he has your family at heart. And that's where he comes from. And I've known Ed for quite a while, and I really appreciate that about him. So it's great to have an attorney that's ready to attack if you're suing somebody. But when you're doing estate planning, your wills, your real estate, you really want somebody that is going to really look out for you and what you're doing. So much appreciated. So thank you, everybody, for joining me on Let's Talk Seniors, Memory Care Issues. And until tomorrow, I look forward to it. If you want to come see our Dogwood House, I would love to show it to you.
Hi, Deirdre here again. Thank you for joining me on Let's Talk Seniors, Memory Care Issues. Is this an issue hitting home? Do you have a parent or loved one with memory care issues who you feel is not safe at home anymore? Are isolation, falls, and safety issues becoming a big concern? Welcome to Dogwood Senior Home, premier boutique residential senior living specializing in memory care. It's country living at its best in the Huntington section of Shelton, Connecticut. We're truly a home with only 6 senior residents living as one family unit. Senior residential homes are concepts sweeping the nation with 47,000 across the U.S. We're pleased to open Dogwood Senior Home as it will be only number 6 for Connecticut. Brand new, sparkling clean, opening mid-June. And safe, we are COVID-free, Residential care homes boast a very low COVID infection rate across the nation. This is due to the intimacy of size and speed in which the caretakers can shift to accommodate immediate needs. They are much safer than the large homes and facilities, as you can imagine. It has been documented that residents have less falls and a better quality of life in a residential home environment. Our home is more affordable than the big box facility. You pay one all-inclusive price, and that price is guaranteed for the life of the resident. With an incredible 1-to-3 caregiver ratio, which you won't find anywhere else. Our friendly, loving caregivers are dedicated and trained in Alzheimer's, dementia, and Parkinson's issues. We're only taking 6 residents, so the home will fill up fast. Call me at 203-689-7562 for a talk and tour. I would love to meet you and your loved one. See you soon. Bye.